Hi, everybody. Welcome, and thank you so much for joining us again. Today, we're going to be talking on our webinar about what it is that you should tell your divorce lawyer, 5 important items to share with your attorney. I am Jennifer with the Weinberger Law Group. We are live, so hopefully you'll learn a little bit today from our webinar. Because we are live, we are able to answer your questions live as we're going along, so feel free to put any questions or comments you may have in the chat box underneath the webinar, and we'll answer as time allows, or if you feel more comfortable sending us a direct message with your question, please do so, and we'll follow up with you after the broadcast. So let's get started. What you should tell your divorce attorney. Our disclaimer: this presentation contains general information, does not constitute legal advice. Please be sure to direct specific questions about your own situation to an attorney. So, give us a thumbs up when you find this information useful. Talk to us because, again, we are coming to you live. Ask any questions by leaving us a message in that chat box below the webinar, and I will do my best to answer you live. So, what you should tell your divorce lawyer. Top 5 important items that we find that you simply must share with your divorce attorney. What are we going to cover today? Well, first we're going to talk a little bit about why we think some people tend to keep things from their attorneys during their divorce process. And then we're going to share with you the 5 items we find really important as divorce attorneys and family law attorneys for you to share with your divorce attorney. And then if there's any questions at the end, I'll be happy to answer them and also give you some information on where you can find additional help. So part 1, why is it that some people feel as though they need to hide things from their divorce lawyers? We have a little quote here for you from Edgar Watson Howe. The man who can keep a secret may be wise, but he is not half as wise as the man with no secrets to keep. And that certainly applies to keeping a secret from your divorce attorney. Not wise to do so. Why do we hide things from our attorney? Well, it certainly can be due to embarrassment. And you'll see as we go on when we talk to you about those top things you should tell your attorney. It's understandable why people can be embarrassed to share, personal details with an attorney who they may not know as well as a trusted friend or family member. And there's also some motivation for people to want to conceal information from their spouse or conceal facts from their spouse during a divorce. And we'll get into that a little bit as we go on and let you know why that's really, really not a good idea. So concealing due to embarrassment. They may be details or there may be situations that you simply just don't want your attorney to know because, again, you may not have that type of intimate one-on-one personal relationship with your attorney. For all intents and purposes, your attorney is your employee. And, there may be details about your relationship or about your children or about your past that you may not simply want the attorney to know. There may be details that you don't want other family members to know, that perhaps if you have, a trusted family member that's been with you through this process and they're, maybe not as in the know as they think they are, once they start to become familiar with the case and, perhaps accompany you to your meetings with your attorney, you may not want them to know these types of intimate details. And also you might not want the court to know, your information because, again, it's embarrassing to have a courtroom or a judge know personal details about your current life or your past. And the other motivation we talked briefly about a couple seconds ago is the want to conceal information from your spouse or soon-to-be ex. Spouses feel guilty about their past behaviors, and they may not want their secrets known by their partner. So, for example, if you've had a past indiscretion, a relationship with somebody outside of the marriage, then, you might not necessarily want your spouse to know that because you don't want your spouse to be hurt. And that's, of course, a natural emotional reaction to something like this having happened in your past. The other motivation is spouses attempting to try to hide or conceal property or to get a quote unquote leg up in the divorce. So, there's an account that's, some sort of Caribbean offshore account that you've been dumping money into that you don't want your wife to know about, or perhaps you've had a gambling issue throughout the marriage that your spouse is not aware of, and you've run up, hundreds of thousands of dollars worth of debt that you've been concealing. The desire is to keep up that behavior, but it's absolutely not a good idea to do that. You're not going to get a leg up in the divorce by keeping information withheld or even being dishonest about information. In fact, it's really just the opposite. You're going to find yourself in a very negative position if you continue to conceal property or facts from your spouse. So is it ever a good idea to keep something important from your attorney? And I'm going to say that the answer to that we find is no. Without all the relevant information to your case, and when we say relevant, listen, you don't have to treat your divorce attorney as if they were your therapist. They don't need every intimate detail about what has happened in your marriage. They need relevant information. So without the information, your attorney can't really appropriately represent your best interests to the court, and they certainly can't advise you on the best course of action for you to take. Don't forget, your attorney is your advocate. They're not your judge, they're not your jury, and they're certainly not your executioner. So you need to know that without having all of the information, your attorney cannot go to your spouse's attorney, can't go to the court and make informed arguments, cannot negotiate from a strong position without all the facts and without all the details about things that would be relevant to your divorce, to divorce negotiations, to mediation, and to ultimate settlement of your case. Let's talk about those 5 items we feel that you should absolutely disclose to your divorce attorney during their representation of you. Number 1, we touched on this briefly earlier, you're having an affair or you did have an affair. Now, of course, you may not want your spouse to know this again, but it may come out anyway. There's a period of time in every divorce, unless it's truly an uncontested divorce, that's called the period of discovery. And discovery is the way that the attorneys get out all of the information in the case. Now, not every case has to go through discovery, but if there are contested issues or questions about details in the marriage, there's going to be the period of discovery. There's going to be depositions, there's going to be interrogatories, which is a list of questions that you have to answer in return. So through all of this, the affair may come out. And depending on the affair, you may owe your spouse money. What do we mean by that? Well, if you've been taking money out of a joint bank account or depleting a marital asset in order to fund this affair, buying your paramour gifts or taking them on vacation, you may have to put that money back into the marital pot. So spending down marital money to, keep somebody on the side, if that's found out, you're absolutely going to be responsible for putting the marital money back into the pot for appropriate division in the divorce. Also, the grounds for divorce could change if there is an affair. There are grounds for divorce. The easiest path of least resistance grounds for divorce is irreconcilable differences. But if your spouse finds out that you're having an affair and they've filed a counterclaim for divorce, they can change the grounds for divorce to adultery. Now, it's, again, unless you've been depleting marital money, there's really no penalty for having an affair as far as the court is concerned. You don't get punished for bad behavior, but it's going to put out details into public documents. And if you have a trial, you're going to have to testify about the affair, and your paramour is also going to be named as a party in the case, and will also have to participate in the case and testify at trial. So you don't want that to happen. So if this is happening, let your attorney know. And also, it may be wise to talk to a therapist about how to share with your spouse. If you're thinking, listen, I may want to sit my spouse down and come clean about this, talk to a therapist about how to best go about doing that. You don't want to cause any more hurt feelings than are certainly going to be there naturally. So, sit down, discuss a course of action with your attorney, with a therapist for the best way to go about revealing this. Number 2, any domestic abuse in the relationship. Again, people who are victims or survivors of domestic violence may be, ashamed or embarrassed to tell even close family members about an abusive relationship or environment. But you need to tell your attorney this without question. Why? Well, you may be entitled to damages. If you've had pain and suffering, if you've had medical bills, you are able to sue your spouse just like you would in a regular personal injury, car accident, slip and fall case for damages, and that's done within the divorce. It's called a marital tort, and it gets to be a little legally complicated. Again, a great reason why you need to talk to your attorney about this. They can give you some guidelines and an approach on how to handle this. Your attorney can also offer you legal advice on domestic violence laws. We have laws here in New Jersey, specifically the New Jersey Prevention of Domestic Violence Act. They can tell you how to get a temporary restraining order. They can tell you how the process goes for converting a temporary restraining order into a final restraining order. They may also be able to represent you in your final restraining order hearing if this is the way that your case is going to go. And your attorney can also steer you to other resources because, we're experienced in this area as family law attorneys, and we know experts, we know therapists, we know local community organizations that can help you with other types of resources beyond legal resources if you need them. Your attorney may also want to explore other ways to serve your spouse with the divorce papers, especially if the two of you are still living together. If you're in a volatile situation, a violent situation, your spouse may react really, really negatively to getting your divorce papers. So your attorney might want to think about a good course of action to get your spouse served with these papers, perhaps serving them at their place of business rather than at the home, especially, again, if you're still living together. But above and beyond, you see there, your safety should always be your number one concern, your safety and, of course, the safety of your children. So the third item you really need to tell your divorce attorney about is any sexually transmitted diseases you may have if your spouse does not know about them. Again, this is a really, really touchy and emotionally uncomfortable conversation to have with your attorney. We get that. But much like with the domestic abuse, you may be entitled to recover damages if you feel as though your spouse actually gave you an STD because of an affair. This is something that you want to explore with your attorney. Again, this is the same thing. It's a marital tort. You could get damages, pain and suffering, medical bills. These aren't easy cases to prove, especially sexually transmitted diseases aren't easy to prove. But there are ways to go about this. So absolutely speak to your attorney about the best way to go about pursuing a marital tort if that applies to you. Conversely, if you may have given your spouse an STD, you may be responsible for paying damages under the marital tort. And this is not something you want a surprise to, come to your attorney that this is happening and a marital tort is all of a sudden being filed against you. You want that attorney to be aware that this may be coming down the pike. And also you, of course, if your spouse doesn't know that you've contracted this, but you've continued to have relations with them, they may need to be tested as well. You don't want them to go untreated or into their new life, possibly infecting other people. If you suspect that you have an STD, but you haven't been diagnosed, of course, go see your doctor. The fourth item you need to reveal to your divorce attorney is if there is now or if there ever has been DIFUS. DIFUS is now known as DCP&P, if you didn't know that. But if there's been any DIFUS involvement in your family, again, now if it's ongoing involvement, or even if the incident was years ago. If the incident was years ago and there was abuse or neglect proven, the court is going to have a file. And the judge, if you conceal this, the judge may just be able to go to your file and look and see what the result of the DIFUS involvement was. Again, not something that you want to surprise your attorney. They need to have all of this information so they know how to address this if it came up. Now, even if the incident was reported by someone else and they investigated and they found nothing and the case was closed, there still could be a record floating around out there about that. So make sure you tell your attorney so, again, it doesn't just pop up in the middle of your divorce case. If the case is a little bit more involved or is a little bit more involved, the judge may want to call in your caseworker for a recommendation if you and your spouse are arguing over custody or parenting time. So again, if there's been a finding of abuse or neglect and you're now separating and divorcing and there's an issue of custody, the judge may want to pull in DIFUS, DCP&P for a recommendation on how to handle awarding custody or parenting time to either of you, again, depending on the involvement and what took place. If DCP&P becomes involved, see an attorney. Talk to your attorney if you already have one immediately, because you absolutely want to have at least advice, absolutely guidance, perhaps representation in any DCP&P DIFUS matter. And the last one you want to disclose to your divorce attorney, again, any and all assets and debts. Never, ever, ever conceal assets from your spouse. By the same token, never conceal assets from your divorce attorney. Again, through that discovery process, assets and debts are going to be found through subpoena, through deposition, which is a sworn testimony that you're going to be subjected to, through interrogatories, through perhaps private investigators, through notices to produce. The court wants and expects complete transparency when it comes to assets or debts. And as much as you may want to bury your head in the sand about the debt that you may have run up with your spouse not knowing about it, it's not going to go away. It's going to have to be addressed. So you might as well just rip the Band-Aid off and reveal the debt. So this way your attorney can advise you the best way for you to approach this. If there are marital debts, you may have to explore bankruptcy. And again, your attorney can steer you towards professionals who can help you with that, financial advisors who could go through your situation. The court will absolutely, positively look very negatively at any attempt to conceal money or property from your spouse. You can be subject to sanctions. If your spouse finds out about it and they needed to hire a private investigator, or their attorney had to jump through hoops to find money or property, you could be on the hook for paying those fees, for paying counsel fees, for paying private investigator fees, whatever the case may be. If you're seen to be purposefully hiding things, the court is not going to be happy with you or with your attorney. Get your attorney a full inventory. Write it all down. Even if you think it's not, a major piece of property. If it's something that you think will, possibly be an issue in the divorce, you have a painting that may not be worth a lot, to a third person, but, you have an emotional attachment to it. These things may come up. So get your attorney a full inventory, assets and debts, really early on in your case so they know what they're working with. Now, we know people are probably still uncomfortable with the subject matter and revealing it to the attorney because you don't really know if what you're saying is remaining within those four walls. And I just wanted to make it a bit of a point to let you know that you should feel protected by what we call the attorney-client privilege. Your attorney cannot reveal any information unless you tell the attorney you plan to commit a crime, or if you tell the attorney that you plan to lie under oath on the witness stand. Your attorney is your advocate, and they have to protect your best interest. Now, of course, they're also officers of the court, and we have a sworn obligation to make sure that the process of the court is as pure as possible. So, if you tell your attorney, listen, I'm going to get on the stand and I'm going to lie, well, that attorney most likely has an obligation to reveal that to the judge. So don't put your attorney in that position. Again, if you reveal it in a meeting, the attorney may turn to you and say, listen, thanks for sharing that with me, but it's really not relevant. And whatever you say will not leave that office. So be comforted in the fact that all of your discussions from day one, from your consultation all the way to the end of your divorce, every discussion, even the notes that your attorney takes, are protected by the attorney-client privilege. So they're private and they cannot be shared with anyone outside of that office. Again, some possible consequences of hiding information from your attorney. Your attorney may find out the information in the middle of the case. That can happen in the middle of a motion, in the middle of an open court hearing. Your attorney may find out information that you didn't share, and that really leaves them at a disadvantage standing in front of the judge trying to come up with an explanation for information that he or she just simply didn't know. The judge, again, if you're hiding things, if you're lying when you're testifying, you may be subject to sanctions. One of them may be contempt of court. So, again, just a situation you don't need to put yourself in, and one that you simply, want to avoid. You don't want to be seen as dishonest by the court. This happens. If you lie early on to the judge, or the judge finds that you're hiding something or concealing something early on, your credibility is really going to take a hit. And now you have the whole case in front of you. So, don't start off on that foot, because once a judge sees you as dishonest, it's really difficult to rehabilitate your reputation with the court. And you also are in a weaker bargaining position. Again, your attorney can't go to the other side ready to bargain and ready to negotiate, only to be surprised during negotiations that everything that you've planned and your position that you're ready to put forward in order to negotiate and bargain is moot at this point, because there's this fact, of your offshore, $2 million Caribbean bank account. Well, your attorney is really not going to be in any sort of bargaining position at that point. So again, consequences that you just simply want to and should avoid. Well, that's it for today's webinar. Thank you again for being with us. Don't forget to subscribe to our Facebook events tab. You'll see it at the top there to be notified about upcoming live webinars, so you know when they are coming. We also have a blog on this topic. If you want to read a little bit more about it, I will post the link to the chat box underneath the webinar when we are done. And of course, again, if you want to put a question there, once we're done, I'll be able to answer it. If you'd like to shoot us a direct message, we can also answer that as well. If you want to reach out to us, especially if you want to schedule a consultation, you see our toll-free number there, 888-855-3014. Give us a call. We have a statewide practice. You can also email us or visit us online at weinbergerlawgroup.com. There you can find information regarding not only what we talked about today, but any other aspect of family law that you may